Now we will read right against exploitation, which is under fundamental right, covered under Article 23 and Article 24. So let's start with Article 23. So what is this Article 23 talking about? Article 23 is talking about prohibition of traffic in human beings and forced labor. So Article 23 is prohibiting traffic in human being and forced labor, or you can say beggar, or you can say other forms of forced labor. And let me tell you, this Article 29, this right under Article 29, Article 23 is available both to citizen as well as to non-citizens. And this Article 23 is available against state, and Article 23 is also available against private individuals. So Article 23 is available to citizen as well as to non-citizen. Article 23 is available against the state, against private individual as well. And when I say traffic in human being, what is the meaning of traffic in human being? It is the meaning of traffic in human being is that selling and buying of human, of men, of women, of children like goods is what we call traffic in human being. Then this includes slavery as well. That means selling and buying of men, women, children like goods are prohibited. Slavery is prohibited under Article 23. And then another thing that is prohibited under Article 23 is forced labor, or you can say beggar. And beggar means two things. This is forced labor, and along with forced labor, no wage. That means without wage. Without wage, when someone is forced to do work, that is what we call as beggar. But there are some exceptions under Article 23. And what are those exceptions? One exception under Article 23 is that the state can impose compulsory service. So, state, this exception is available with state. That means state can impose compulsory service. But why? For public purpose. That means for public purpose, state can impose compulsory service. For example, military service, or let's say social service. So, for that, state can impose compulsory service for any public purpose. State can do so without paying. That means when the state is imposing compulsory service to you for public purpose, that time state is not bound to pay you for your work, for your contribution. That means when the state is imposing compulsory service to you for public purpose, at that time state is not bound to pay you. But one thing that the state needs to take care is that state, while imposing the compulsory service, state cannot discriminate only on the grounds of religion, race, caste, or class. That means, yes, the state can impose compulsory service for public purpose, and for that state is not bound to pay. That is okay. But state should take care one thing, that state should not discriminate only on the grounds of religion, race, caste, or class. Okay. But then except these things, race, religion, caste, class, on other grounds state can discriminate you. For example, on the grounds of age, residence, sex. For example, state can only ask that people of the age group of 15 to 59, they have to come and do the compulsory service. State can do so. State can discriminate on the basis of age. Or state, for example, suppose in a particular area there is some calamity, and for that calamity the state can ask that only the people of that area should do the compulsory service. State can do so. That means state can discriminate on the basis of age, on the basis of residence. But what state cannot do is that state cannot discriminate on the basis of religion, race, caste or class. So this is Article 23. Now we will read Article 24. Now we will read Article 24, which is again comes under right against exploitation, and Article 24 prohibits the employment of children who are below the age group of 14 years in any factory or let's say any hazardous activity. So Article 24 is prohibiting the employment of children who are below the age group of 14 years in any factory or any hazardous activity. But let me tell you, the children who are below the age group of 14, they are not prohibited in their employment in any harmless or innocent work. So they can do any harmless or innocent work, that they can do. But what they cannot do is that Article 24 is prohibiting employment of children who are below 14 years of age in any factory, in mine, and let's say for any hazardous activity. Or in other words, you can say Article 24 is prohibiting child labor. So Article 24 is prohibiting child labor, and in this purpose there is an act in India, that is Child Labor Prohibition and Regulation Act of 1986, and this Child Labor Prohibition and Regulation Act 1986, this has been recently amended in the year 2016. Now let's talk about right to freedom of religion. So right to freedom of religion covers Article 25 to Article 28. Now let's start with Article 25, which is talking about freedom of conscience and free profession, practice and propagation of religion. So Article 25 is saying that all persons are equally entitled to freedom of conscience, right to profess, practice and propagate religion. And when Article 25 is saying all persons, that means it is available to citizens as well as to non-citizens as well. But here again there are some restrictions, and this is not, Article 25 is not absolute fundamental right. There are some reasonable restrictions. So what are those restrictions? Those restrictions are, you can say, public order, morality, health and other provisions of fundamental right. And you can say there are some other exceptions as well. And what are those exceptions? Those exceptions under Article 25 is that the state can regulate or restrict what the economic activity or the financial activity, or you can say the political activity, or you can say any other secular activity which are associated with religious practice. That means Article 25 is giving this right, but Article 25 is not absolute. These are subject to public order, morality, health and other provisions of fundamental right. And there are some exceptions under Article 25, and one of the exception is the state can interfere, the state can regulate or restrict any economic activity, any financial activity, or you can say any political activity or any other secular activity that is associated with the religious practice. So this is one thing. And another thing is that the state is provided with power for social welfare or reform. So state also have the power of social welfare, or you can say reform. For example, throwing open of Hindu religious institutions which is of a public character to all the classes and sections of Hindu. That means suppose there is a Hindu religious institution. So suppose there is a Hindu religious institutions of a public character, then what state can do? State can throw open these Hindu religious institutions of public character to all classes of Hindus, all sections of Hindus, to all class and all sections of Hindus. State can do so. So these are the exceptions under Article 25. Now we'll read Article 26, which is talking about freedom to manage religious affairs. So Article 26 is talking about freedom to manage religious affairs, and Article 26 is talking about that every religious denomination shall have some rights. So every religious denomination shall have some rights, and what are those rights? Those rights are the religious denomination can establish and maintain institutions which are for religious and charitable purpose. So every religious denomination can establish, maintain institutions for religious and charitable purpose. Then what are other rights available under Article 26? That the religious denomination can manage its own affairs. So the religious institutions, the religious denomination can manage its own affairs in matters of religion. That is another right available under Article 26. Then another right is that the religious denomination can own and acquire movable and immovable property as well. This is another right under Article 26. And another right under Article 26 is that the religious denomination can administer such property, but that should be in accordance with the law. So it can also administer such property. So these are the rights available to a religious denomination under Article 26, and those are the religious denomination can establish, maintain institutions which are for religious and charitable purpose. It can manage its own affairs in matters of religion. It can own, it can acquire the movable and immovable property, and it can also administer such property, but that should be in accordance with the law. So it should follow the law. That should be in accordance with the law. And again, this Article 26 is not absolute, and these are subject to public order, morality and health. So these are the grounds on which Article 26 can be restricted: public order, morality and health. Now let's talk about Article 27, which is talking about freedom from taxation for promotion of a particular religion. So what is Article 27? Article 27 is talking about freedom from taxation for promotion of a religion. Now listen what Article 27 is saying. It is saying that no person shall be compelled to pay any tax for the promotion or maintenance of any particular religion. Now, for example, let's assume there is a person and the state is forcing this person to pay tax, and with that tax the state is promoting or maintaining any particular religion. Then let me tell you, that is prohibited under Article 27. That means no person shall be compelled to pay any taxes which will be used for the promotion and maintenance of any particular religion. Now you can say this Article 27 in other words also. That means suppose there are some public money and state has collected this public money by imposing tax on the people. So now let's assume there are some public money with the state available. Now the state cannot use this public money for the promotion, for the maintenance of any particular religion. The state cannot do so. So that means Article 27 is prohibiting the state from using the public money for the promotion and maintenance of any particular religion. Now you can understand Article 27 in another perspective also, that when we are saying the state is prohibited to promote or maintain any particular religion, that means in other words you can say that this public money or the tax from the people that is collected and that is available with the state, that tax, that public money can be used for the maintenance of all the religions. That means the state cannot promote or maintain any particular religion, but this public money collected through the tax can be used for the promotion of all religion equally. That means from Article 27 what you can understand, that India is a secular state. That means the Indian state will not use the public money for the promotion of any particular religion, but it can use for the promotion, for the maintenance of all the religion equally. Now we will read Article 28, which talks about freedom from attending religious instruction. So Article 28 is talking about freedom from attending religious instruction, and Article 28 is talking about 4 types of institutions. And what are those 4 types of institutions? One is the institution which are wholly maintained by the state. So one type is the institutions which are wholly maintained by the state, and in this type of institution the religious instruction is completely prohibited, is not allowed. This is one type of institution. Then another type of institution is that the institutions, those are administered by the state but established under any trust, for example. So another type of institution is institutions which are established by religious charitable trust and which are administered by the state. This is another type. And let me tell you, in these type of institutions the religious instruction is permitted. Now there are another two types of institutions. That is the institution which is recognized by the state, and another type, the institutions which are receiving aid from the state. Now in these two types of institutions which are recognized by the state and which are receiving aid from the state, in these two type of institutions the religious instruction is permitted but on a voluntary basis. So let's recap. So under Article 28 there are four types of institutions. The institutions which are wholly maintained by the state, and in that type of institution the religious instruction is not allowed. Then another type is which is established by religious charitable trust but which are administered by the state, and in this type of institutions the religious instruction is permitted. And another two type is institutions which are recognized by the state and the institutions which are receiving aid by the state. In these two type of institutions the religious instruction is permitted on a voluntary basis. So this is Article 28. Now we will talk about Article 29 and Article 30, which is talking about cultural and educational rights. Now this right under Article 29 and Article 30, cultural and educational rights, these are exclusively available to citizens. That means these rights under Article 29 and Article 30 are only available to Indian citizens. Now let's start with Article 29, which is talking about protection of interest of minorities. So Article 29 is protection of interest of minorities. Now let me tell you, the term minority is not defined in the Indian Constitution. So what this Article 29 is talking about, any section of citizen who are residing in the territory of India and those who have a distinct language or script or culture of their own, they have the right to conserve their language, their script, their culture. That means what this Article 29 is saying, suppose there are some sections of citizen in the territory of India, those who are residing in the territory of India, and they have a distinct language, script and culture of their own. So under Article 29, they have the right to conserve their distinct language, their script, their culture. So this right is available under Article 29. And another thing is that no citizen shall be denied admission into any educational institution which are maintained by the state or receiving aid. So which are maintained by state or which are receiving aid from the state. In those kind of educational institutions, no citizen shall be denied admission only on the grounds of religion, race, caste or language or any of them. And Supreme Court has clarified that this phrase sections of citizens means minority as well as majority. Now Article 30 is talking about right of minorities to establish and administer educational institutions. And Article 30 is talking about all minorities, whether they are based on religion or whether they are based on language, shall have the right to establish, to administer the educational institutions of their choice. And another thing is that when the state will grant aid to the educational institution, the state shall not discriminate grant whether on the ground whether that is under the management of a minority, whether based on language or religion. That means the state shall not discriminate in granting aid to the educational institutions on the ground that it is under the management of a minority, whether based on religion or language. So the state shall not discriminate.